morning. Today I want to discuss about one new Supreme Court judgment, and this of course the standard of judgment seems to be somewhat surprising to me. AR 2019 Supreme Court Party 194, while dealing with Specific Relief Act and Contract Act, surprisingly the Supreme Court has held that the vendee, the proposed purchaser of the land, who entered into an agreement for sale with the landowner in the year 1964, after paying 70%, 75% plus consideration, withholding 25% minus consideration, because there was litigation pending. One of the clauses for agreement for sale was that there was cases pending, and completion of these cases, the term was that the sale should be executed. But since the vendor failed to execute the sale deed, suits for specific performance was filed, and all the courts agreed the relief as prayed for. But unfortunately, the Supreme Court, by setting aside all the judgment, simply held that there was no payment of rent for 13 years because the person who was given in possession after receiving considerable consideration was cultivating and yielding lot of income from that land. Though the Supreme Court has said that there was a term for payment of rent, but when they have narrated the other conditions about the agreement, the Supreme Court not mentioned what was the agreement clause 3 between the vendor and vendee. But finally they say section 51 of the Contract Act says there should be readiness and willingness to perform. The failure to pay the rent shows that the readiness was not there. Therefore, the Supreme Court held that the specific relief could not be granted. Then question arises, the provisions of section 16C Specific Relief Act says that the performance contract cannot be enforced in favor of the person who failed to prove that he has performed or was always ready and willing to perform the essential terms of the contract which were to be performed by him. Under this, they say that this failure to pay the rent was tantamount to readiness was not there practically. Then the Supreme Court has given this judgment after very long years. This is too unfortunate, and this judgment has to be revisited. Kindly go through the judgment. Best wishes.